Welcome to a very special Halloween lecture. And when I say a Halloween lecture, I mean it's me sitting in my room with a flashlight under my chin. Whoa! Yeah, I know, I'm weird. We're going to talk about really scary topics. You know, forensic science has all sorts of really scary things that you could talk about. And we're going to be talking about evidence admissibility in the court of law. Okay, I'm not going to do the ghost voice anymore. What if everyone talked in the ghost voice? Anyways, I want to make this lecture quick. This is part 3 of the lecture. First one was Bill of Rights. Yeah, I'm going to do this in the dark. Was the Bill of Rights and seeing how different amendments to the Bill of Rights, or different amendments in our Constitution, influence the way that evidence is perceived, okay, and the way that that trials actually run, and we make sure that there's due process and we have a whole system in place. The second portion of our lecture started talking about types of evidence. There's direct evidence, things like eyewitness, things like surveillance cameras, direct evidence like that, confessions, versus indirect evidence, which is more circumstantial evidence like blood, fingerprints, things like that that have to be analyzed. There's also class evidence and individual evidence, where individual evidence can be tracked back to an individual person or source, okay, like a fingerprint or like large, or like a bullet even can possibly be tracked back to a certain gun. And also there's class evidence. Sorry, I'm actually sick, so I'm trying to get through this. Class evidence is more along the lines of you can only track it back to a certain group. Okay, so like paint on an automobile, or really small glass fragments, or things like that, where you can track it back to a similar object, but not to a specific one. So we're going to talk about how evidence is admissible in a court of law and a little bit of the history of that. So there are court precedents that determine the admissibility of scientific results. Okay, a court precedent means that there was a landmark court case that happened, and then after that court case, everyone kind of looked back to that court case to determine what to do in the future. One of those was Fry versus the United States in 1923. This was, of course, this was a court case that dealt with the use of polygraph, of lie detector tests, and whether or not those should be admissible or not, because it was a brand new technology. And so basically what the Fry standard was for the longest time, for like 70 years after this, actually 80 years after this, I think, was that a questioned scientific procedure or principle must be generally accepted by a majority of the scientific community. So you couldn't come in and just say, hey, I got this new technique, nobody's ever heard of it, but we're going to use this to test the evidence. It must be something that was generally accepted. And so the Fry standard was one that lasted for a long time. There was some changes to that over the years, but then when we got to the Daubert versus Merrill Dow Pharmaceuticals in 1993, so you know we have 70 years later now, you have this replaced the Fry standard, okay? And so the judge is the one who then determines what is permissible to use as evidence in the court, and what is, you know, what methods could be used, and if a person actually has the credentials to be labeled an expert. And so there's the questions here. There's areas of inquiries where the judge can ask us, can the scientific technique be tested? Has the technique or theory been subject to peer review, meaning other scientists have vouched for it? What is the technique's potential rate of error? Are there standards to control the technique's operation, or are these maintained? Or has the technique or theory attracted widespread acceptance within the scientific community? Okay, it has to meet these requirements for it to be able to be used in a court of law. Okay, when it comes to federal rules of evidence, okay, these are kind of based off of those same questions. An expert testimony is hearsay from a witness, or excuse me, hearsay from a witness is not normally allowed in court except in the case of an expert witness. And so a witness, by definition, is qualified as an expert by knowledge, skill, experience, training, or education. And so they can only give scientific testimony if it's based upon scientific facts, if it's the product of reliable principles and methods, and if it has applied the witness has applied the principles and methods reliably to the facts of the case. You see those go back a lot to the questions that the judge can ask, okay, and that can make you an expert witness in the field of forensic science. Okay, court significance of procedures and evidence collection and analysis. Okay, we're going to get on this a lot more next unit whenever we get into crime scene, but it's important for us to start looking at this. Every step in handling, analyzing, transporting, or storing must be pristine because it's going to be scrutinized in a court of law. So there's guidelines that must be followed. You need to have a systematic search for all evidence. We're going to know how to do that very soon. All evidence must be collected, including large items, and trace evidence must be vacuumed. There's actually special vacuums for it. Continued. Comparison type evidence should be collected when possible. These are things that you can go back into the lab and you can compare them to. So like if there is a hit and run, you would take paint samples off of the car. If there's you would take blood and hair analysis from all family members. If there was a murder that took place or an attack that took place, you take blood and hair samples from the victim, the suspects, all family members, including pets, and the crime scene investigators, so that when you go back to the lab, you can compare those to make sure that, hey, this hair here is actually from one of the crime scene investigators, or it's from Fluffy, my pet poodle. Okay. Then you use those for comparison, elimination, and matching so that you can figure out and try to piece together what happened at the crime scene. Proper packaging and separation of evidence is crucial. We actually will have evidence bags, and I'll show you how to collect certain types of evidence. And so you'll need the proper tools for that. You need to make sure that they don't come in contact with each other, that they're packaged individually, that you follow strict packaging guidelines, and you're keeping notes all along the way, and that also if you go from crime scene to crime scene, that you're not bringing evidence with you or bringing even like shreds of or blades of grass or anything on your shoes or anything from crime scene to crime scene. So decontamination of personnel is also important. Chain of custody. You've heard us talk about this. That this is basically the written and witnessed record of everything going from the crime scene to the courtroom. So you got to know when it got collected, where it is, for what purpose. You need to know how it was collected, who recorded it. Basically, you need to know everything about how evidence got from the crime scene to the lab to the evidence locker to the courtroom. That at all times that there's no time that evidence is just missing in action. Because then it is not admissible in court. And so anytime you take a sample, okay, from the evidence, it needs to be documented, and every individual who processes the evidence must maintain a written record, okay, and may be called to testify in court to say, hey, I took good care of this, or maybe called in to find out that, hey, you didn't take such good care of it. And so that is chain of custody. And so that's as far as we're going to go with our legal systems. And you'll need to be able to put together all of this information, Bill of Rights, types of evidence, and then ultimately how it's permissible in court and the chain of custody. Have a lovely All Hallows Eve.